Welcome to the NC DWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NC DWI guy, Jake Minick.
Hello, fellow freedom fighters, and welcome to episode 12 of the NC DWI Guy podcast. Today, we have a special guest on the program, Doug Scott. Doug is a former law enforcement officer with more than 20 years of law enforcement experience and hundreds of DWI arrests. He was the first certified DRE in North Carolina, the first certified DRE instructor in North Carolina. He helped to get the North Carolina DRE program off the ground. Doug has attended countless seminars and courses on the pharmacology of alcohol. You'll hear more about that in episode 13. His curriculum vitae stands at a massive 50-page long explanation of his credentials. Doug is an incredibly prepared expert in every way, and we're very fortunate that he has agreed to take the time to talk to us today about the importance of having an expert witness involved on your case. He'll also be back for episode 13, next episode, where he is going to do a mock voir dire. So kind of what I thought we would do today, Doug, in terms of purpose is really to go over a little bit about why an expert can be helpful on your DWI case, and then also kind of go through a sample voir dire in terms of trying to tender as an expert, expert witness. So in terms of why an attorney should get an expert witness involved, and there's all kinds of different experts that might be helpful to a case, but in terms of just kind of a, kind of broad general response, what is helpful about having an expert involved on your case?
Well, in my experience, which I've been doing expert testimony for about 12 years now, that attorneys may not understand the topical areas in the depth, obviously, that an expert will, and may overlook really critical things about the case, which the expert would be able to identify when they evaluate the discovery video, and make a much stronger case for the defense attorney by using them. The expert witnesses, I think they're going to look, if they're good, they're going to look at the state's case's strengths as well as the weaknesses, and they're going to let you know about those strengths. And if they're honest, they may actually say, help you to know when you should seek a plea, or may choose not to go to trial because of something. But I think their experts are just really helpful because they have such a greater depth of understanding and silos, so to speak, of information. And a pharmacologist has a little different way of looking at things than a toxicologist, for instance. Using me as an example, I've studied pharmacology, but I also was a law enforcement officer. I taught standardized field sobriety tests, so I look at those with a very critical eye. I was a drug recognition expert instructor, so I look at that, the absence of the use of DREs, as well as how they use a DRE in certain cases. But contrasting those, a pharmacologist, a PhD in pharmacology or toxicology, will not know the DRE protocol, will not be able to testify as an expert about that and won't know anything about horizontal gaze nystagmus. So sometimes a case is better suited to someone, an expert who may have a broader base of knowledge in a more comprehensive area than, say, a strength. And as a friend of mine says, with a PhD, he says, I know a topic a half inch wide and a mile deep.
Right.
Sometimes it's better to have that guy who knows the, couple of 100 feet deep, but a mile wide.
Right. Yeah, no doubt. I think one of the maybe misnomers in terms of expert witness is the witness part of it, because I think that for a lot of us, when we think of an expert witness, we think of the person that is kind of helping us when the case is, kind of set for trial in the courtroom, and talk about the value that an expert can actually provide well before you get to the case being set for trial, or certainly before testimony begins. What is it that you're kind of doing in your process before the case is ever in the courtroom?
Yeah, I think that's certainly 50% or more of the value of an expert. The first thing I do is, review the case, all the discovery videos. And so that way we get, that old two minds are better than one sort of approach, at least a second set of eyes looking at everything. I like to brainstorm with attorneys and discuss the strengths and weaknesses and areas that to avoid, areas to expand on during trial. Also can get involved and go and do a site analysis at the site of the arrest. I've look at the condition, take pictures. Was it a suitable location to do standardized field sobriety tests? What was the lighting like? What's traffic like there? And experts can do, in some cases, their own experiments. I recently did a full DRE evaluation right after a man was arrested. In fact, he was brought to my home by an attorney, and I did an evaluation within less than an hour after he was seen by the law enforcement involved. So that's just an example of some of the things that an expert can do. And then also scientific literature review. We may already have, and when you say I have, a library of scientific literature at my house. I'm always accumulating it, doing research at the Health Science Library at UNC or at college libraries, and downloading what would be expensive articles, typically $40 or more, for free at these university libraries. So the experts, some of them still have access, like Dr. Wilkie Wilkins at Duke. We have greater access to that scientific literature and may already have an abundance of applicable literature where you as an attorney wouldn't have to spend any time or have any of your staff trying to identify relevant literature. So I think those are the real advantages, just off the top of my head, about involving an expert and not, in considering them more of a consultant than just a witness.
I definitely think that has been tremendously powerful in terms of the times that we've had you involved in some of our cases. And I would say particularly on the research end of things, there's, last case that I can kind of think back to was a habitual DWI case where there was kind of a serum a sample that was taken at a hospital, and getting all of the kind of literature that you had done research on but then also kind of digesting that and being able to explain what these articles are trying to communicate. Here are the kind of specific, places within those articles that are helpful in terms of bringing out with during testimony and using in arguments was tremendously helpful in terms of kind of, again, trying to take my shallow knowledge of that, serum sample type of analysis to a much deeper level in a very short amount of time, because you had kind of done all the work on it previously.
I appreciate you saying that. And that's my hope. Marijuana is a great example.
Right.
In, I think 2017, the U.S. Department of Transportation released about a 35-page report on marijuana impaired driving to the U.S. Congress. And it is chock full of great quotes that you can extract from it, information that is really enlightening related to the issue of marijuana impaired driving, and I think very helpful for defense attorneys. It's been remarkable to me that very few people, and even some of the other experts that I communicate with, were not aware of that government publication.
Right.
It's very difficult, I think, for the state to argue that there's no credibility or a lack of credibility in the information contained in a document that's provided by the U.S. government to Congress. So
I think that's where an expert, again, just comes in so handy, because as attorneys, I think we're really kind of looking at the statutes and the case law, and so oftentimes missing the SFST manual and missing the research articles that have been done in peer-reviewed studies, and missing the documents from Congress that might be helpful when it comes to a particular issue. And yes, those things may not be referenced in case law, but they clearly are important in terms of communicating to a judge or a jury the reason why certain evidence is or is not important.
Sure. I think many attorneys, for reasons I don't understand, appear to think they have to understand and be their own expert in a lot of cases, and letting go of that is just so helpful. And letting a consultant help you, it's just going to be much more powerful and reveal so much more information. I think it's simple. You're spending your time doing CLEs related to your job. Your experts spending time, if they're truly maintaining an expertise, reading pertinent scientific peer-reviewed journal articles and doing continuing education courses, specifically and narrowly related to their area of expertise. So they're going to have a much better command of pharmacology, as an example, marijuana as a drug, than you'll be able to do without putting an awful lot of lamp in the oil in that midnight lamp you're burning. And
right.
So we can save you time and make you more efficient.
Well, in terms of kind of shifting over to maybe kind of the expert side of things within the courtroom, before we maybe try to do a brief kind of sample of a voir dire back and forth, what would you suggest in terms of attorneys that they would be a place for improvement, or maybe a better way of thinking about it would be, what are some of the biggest mistakes that you see attorneys make when it comes to examining an expert witness, whether that's kind of in terms of preparation or in terms of actual courtroom process?
Well, I think both are really important, and they're both weaknesses for a number of attorneys, unfortunately. And the first one would be failure to prepare. And I'd say is, you do have to understand the topic well enough to ask follow-up questions. Even if you've got if you've been given a list of direct questions to ask your expert, and a list of cross questions for the state's experts, if you don't understand the topic well, you can open a door with a question, say, during cross-examination of a state's expert, but not know how to walk in the room once you've opened the door, and because you don't know the follow-up questions, so to speak, using that analogy, to ask,
Right.
And that's what I guess, sadly, I've observed so much that I'm sitting in the courtroom just wincing and pain because the door was open.
Right.
But then the defense attorney stopped. They didn't ask any more follow-up questions. And I think it's likely because they didn't prepare enough to know what follow-up questions to ask, to understand the information well enough, or they're under such stress during that trial that they have difficulty slowing down their mind and thinking analytically about, oh, wow, that guy just gave me an open door, and now I need to follow up on it. I need to, and maybe another thing, and I'm rambling a bit, but another thing is probably thinking about how I understand the information, but how am I going to make sure the jurors are being taught? It's an educational process.
I would say that's particularly true with expert testimony, because if you present all of the expert testimony through, scientific concepts and scientific language, but then don't connect it to why is this person impaired by marijuana, or why is this person drunk, it's really going to be lost in a lot of ways on the trier of fact, whether that's the judge or the jury. So yeah, I think that's a really important part of the preparation process, is how do I take this, overarching scientific principle and then communicate it in a way that a, average person can understand.
Yeah. To go to that, I think it's an old saying for me, is they don't know what they don't know. So I often see or a sense during trials that the defense attorney feels for some reason hurried. And I always want to go slow down, make sure that the judge or jurors that they get it explained, and so now they understand the relevance of the information that you've laid out, and don't expect them, play to the lowest to understand it. Play to the lowest common denominator on that jury, and make sure that you have asked enough follow-up questions so that it is explained well, and they understand the relevance of that expert testimony, whether it's whether you're impeaching the or trying to impeach the testimony of the other side, or trying to develop credibility and understanding for the expert testimony from your side. That's clearly a problem, I think. And slow down and think analytically about it. I've never been an attorney, so I don't want to hurt anybody's feelings in that. It's got to be a difficult thing to do, to try to keep it all together mentally. What's being asked? What's being answered? What's my next question? Is the jury getting this? It's quite a complex task you guys have, but that's it. Slow down, think analytically, and look at your expert. Sometimes I know I'm trying to give face signals like ask a follow-up question, don't stop there, kind of thing. And that goes for your preparation too.
Right.
Trust your experts. We do know more probably
And I think that, part of it too, you do kind of want to make sure that you are prepared in terms of the question that you're asking, but certainly in terms of, one of the benefits of having an expert witness. And then I think this also comes to trusting your expert, is that you don't want an expert that is sugarcoating anything for you. And I know that, I've sent you a number of cases where you've looked at the report and, kind of after looking at it, it's kind of like, this is not a good case for trial. And that, I think, is a good, it's a good communication piece for me then to go back to my client and say, we've had, an independent person review this. It's not, there doesn't appear to be, an attack where we, maybe we're thinking there might be some sort of an angle or question mark. This has been reviewed, so it helps with that kind of conversation. But it, again, also just helps in terms of the courtroom when you have a expert that is just looking at the circumstances, looking at the facts, and then offering a valid opinion. I think that is a really helpful thing, both in terms of client communication, but then, like you just said, also trusting your expert in the courtroom as well.
Yeah, I was you're right about all that. I was just looking at a note I had written, and reminded me of a case talking about preparation and kind of going back for a minute. I'm going to tell you a short, very short story. I had a recently before the courts were shut down, a case where the defense attorney asked me to send look at the discovery and send the report. So I sent them an 8-page typed report on their case, and it was comprehensive. And then they sent me back an email and asked me if I would be willing to prepare them a list of direct questions to ask me. Those were in the 8 pages that I prepared. So what does that tell me? The attorney clearly had not read the 8-page report that I'd gone to the trouble to write. And I'm laughing. Look at your face on my computer screen. I saw you smiling too. That I don't charge an excessive amount for my work. I try to be reasonable.
Very reasonable.
And I did not really charge enough for an 8-page type report that already had direct questions bulleted within it, to have an attorney who then didn't read my report and asked me to provide something I'd already provided to them. So really, it's read other reports, and a lot of times it's really easy to take the direct examination questions from that material. And I often provide enough that even you can create a great list of cross-examination questions for the state's witnesses from what's in my report as well.
That's great. No, and those reports are extremely helpful. Again, regardless of whether you are called to testify as an expert in a case, to get a second set of eyes looking at a report that is an expert set of eyes at minimal cost is kind of a, it does make sense not to kind of tap into the resources that are available when you have the ability to do that. So,
yeah, I want to add, I was at a CLE for experts and defense attorneys in Raleigh that IDS put on a year to 2 years ago. And the executive director, I believe was at that time Tom Mahar. I may not be pronouncing his name correctly, but he asked a question. He said, how many of you all in here have used experts at district court level? And there were very few, probably 100 people in the room, and very few hands went up.
Right.
And he goes, I've asked my staff, why not? We've got money for that in appointed cases. And so I want to make the point also, don't be afraid to file a motion and ask for appointed fees if you if you've got clients who can't afford a witness on their own, because I haven't had a case denied for expert fees that I can remember in the last 8 years or so. So it's not that they. A lot of times I hear, well, my client can't afford one. Don't be afraid to ask, or try to seek that out through IDS as well, not just at Superior Court either. But if you don't think it'll be practical, or your district court judge is better than anyone else in your own area. So, but don't forget about that.
Yeah, I think that's a really helpful point, that is available, and it is really meant to kind of level the playing field, because in most DWI cases, you have one, if not multiple, state witnesses that are getting tendered as expert, whether that's as expert in HGN, administration of standardized field sobriety testing, pharmacology, toxicology, DRE, whatever it might be that they are getting tendered as an expert in. And so it's kind of it's already a one-sided show in a lot of ways, because there's, only state witnesses in a number of DWI cases. There's, no witnesses whatsoever on the defense end. But if there is an opportunity to present a good defense witness that can undermine, some of the testimony that is being made by an expert, it really is just leveling the playing field.
Absolutely. I mean, and I think that's the selling point. The state's got their officer. They've got the DRE. They've got the chemical analyst. They've got the lab analyst. They'll sometimes bring in, a local pharmacist, or even, or qualify the lab analyst as an expert in toxicology, or so
accident reconstruction, whatever it might be.
Yeah, you're right. It's absolutely unfair to your client if they can't have an expert as well. And so I know that's how a lot of it's been put forward. I wanted to say something about not putting on evidence and believing that you have a better chance with the last argument.
Yeah, I would love to hear your thoughts on that, Doug, because that's definitely something that I think we as a defense bar spend a lot of time kind of talking about with each other. Should we put on evidence? Should we have the last closing? If we put on evidence, does that kind of tell the judge or jury that we have some sort of burden of proof? Or by not putting on evidence, are we able to kind of say this is all on the state? So yeah, would love to hear your thoughts in terms of kind of that particular mental dilemma.
Yeah, let me just say that in my experience and observation now, I'm guessing maybe 24 cases, I've had the opportunity to see a defense attorney choose not to put on evidence after having hired me. So I was able to watch and see the whole trial and then see what the effect was. And overwhelmingly, it does not give them an advantage. They have lost the cases. Well, I don't want to say they've lost the cases, but the outcome of the case has been a guilty verdict. And in virtually all of those cases, I would say I believe that the jurors did not understand the significance of what they hadn't heard maybe from the state, and where a defense attorney could have taken an expert and pointed out to the jurors how weak the state's case was, how they failed to investigate, failed to engage a drug recognition expert, how the pharmacology was not consistent with science and impairment, how the officers failed to do field sobriety tests, and what the significance of that was. They left it all to their own ability to articulate a strong closing argument. And well, it better be a damn good one.
Right.
To get all that across in closing, that you could get across in several hours or more, depending on the case, with one or more experts, and actually give the jurors time to hear that from a credible witness, to digest it, to compare and contrast to the information they've been given by the state, and through follow-up questions with your expert to teach the jurors the significance of the lack of DRE evaluation, of the inconsistencies between the evaluation and the officer's training, their symptomatology matrix, where they weren't correlated, say, or how the information the state failed to provide about the pharmacology of the drug, which is why it's not likely the person was impaired. I'm rambling on here, as I'm
I think
well known to do.
No, I think that that's really a helpful kind of thing to think through. I mean, I think some of that is a pride issue for us as attorneys, that we think that the jury is really putting a lot of weight into our closing argument, and we want to be able to address whatever the prosecutor is putting in their closing. But, as I think it's case specific in terms of when you want the ability to let the state present its case and just rely on the fact that they haven't proven their side beyond a reasonable doubt, versus appearing to have any kind of burden of proof if you put on evidence.
Yeah.
But on the flip side, when you get closing argument, last close, because you haven't presented any evidence, then you have forfeited the opportunity to present evidence last. So you've kind of, decided that the arguments are more important than the evidence, because the state gets to present its evidence first, and then you have the opportunity to kind of be the last word when it comes to evidence. Again, state could present rebuttal evidence, but a lot of times don't when you put on evidence. So you get the opportunity to present last evidence. And I think that a lot of times jurors are, and I would say jurors in particular over judges, but I think jurors are putting, a lot of weight into the evidence. And so again, like you said, if you've already lost the evidence war and now they've already heard from the prosecutor, you better have a damn good closing argument by the time that it's your turn to
awful good. Yeah. Well, what I think is, I've talked to jurors, I've had that opportunity too. And of course, I had the opportunity to talk to jurors following criminal cases when I was a police officer for over 2 decades as well. So I've seen this from both sides. And, they go, well, I've heard them say, well, the defense didn't have any evidence. That they heard everything from the state's perspective, and look at it like a scale, the scale of justice. Well, if the state tells them everything that they know and they don't understand it well, or don't understand why it's not logical or credible or scientific, then that scale is still sitting there, bottomed out for the state side. If you're expecting your closing argument to pull it back the other way, I'd say think twice about that. I really have not seen that work out well.
I think it's really important.
One or two cases, and unfortunately, James, I'll say this, and I won't name any names, but I can tell you that I've seen some very unfortunate cases where I actually said before, when we had a conference before, after the state closed, and they told me they were planning on doing that, I've voiced my concerns as tactfully as I can, and can think of one right now where there was just no evidence of impaired driving at all.
Right.
But and the defense attorney had done a great job of objecting and keeping some testimony out, but then he never told the jury really why that was significant that they didn't hear and his client was found guilty, and unfortunately was a friend of mine from college. And so I really felt inclined to tell her that I thought it was a bad move, which I try not to ever ask for permission from attorneys before I talk to the clients.
Right. No,
sometimes, but that's just when I'd say, man, really think long and hard about that. I add this question to the jurors, do they know what they don't know? And can I get that to them just in a closing argument? It's unlikely, I think.
Right. I mean, you got a lot to explain in a closing, just dissecting the evidence. And then you're also trying to kind of help jurors understand what proof beyond a reasonable doubt is. And when you don't present evidence, I think that's what you're relying on is this, kind of standard of proving something beyond a reasonable doubt, which is so foreign to most of us in terms of trying to analyze things through that lens. So again, it's just I think it's a case by case determination, but I like the kind of thoughts that you've offered, because I do think that they are in some ways kind of countercultural in terms of how we approach cases as a defense bar, with our mindset being, the standard of proof in a lot of ways is on our side, and we're going to rely on that. Maybe that kind of strategy works better in district court than once you get to a jury. But I think there's a lot of jurors that want to hear, from the defense side of the table, and you can do your best in voir dire with the jurors to explain, we're under no obligation to present evidence. What would you do if I didn't present any evidence? These are questions that I ask pretty routinely in voir dire. If I, stood over here and didn't ask any questions on cross-examination and we didn't present any evidence whatsoever, would you still be able to find my client not guilty if the state has not met its burden of proving beyond a reasonable doubt? And they all nod their head and say, yes, I'll do that. But I know in the back of their mind, they're thinking, why would you do that? I think one of them once said to me, well, maybe I could, but I think you're a pretty bad lawyer.
Yeah. I sit there and think, this just doesn't make sense. In the opening argument, you're going to hear from our expert, Mr. Scott over here, and they point to me and, why this is not a good case, whatever. I'm just saying, trying to be a little simple there.
Right.
And then you, at the end of the state's evidence, you say, we're not putting on any evidence. What are the jurors left to assume? But, well, they had an expert witness, but they didn't put him on. So he must not have found anything wrong with what the state said.
Right.
I mean, you got to think through that. If you're not going to put on any evidence, don't tell the jurors you've got experts in the room or what that guy over there sitting there for 2 days taking notes. Don't tell him he's an expert for your side unless you're going to call him.
Right. Exactly. No, that's absolutely. Yeah. I've definitely seen that backfire on the state a number of times, not so much on the defense end, just because we so routinely don't present evidence, but where the state has said, here's what you're going to see in evidence, and then it never comes out. It's, objected to and sustained, or they just are never able to present that witness for one reason or another. And it's such a distraction to the jury, even if it is a non-issue. The fact that they were promised this was going to be brought up in trial and then it never came up is kind of like this major deal for the jurors, that they're thinking, why was this not presented, even if it again is a non-issue. Join us next time on the NCDWI Guy podcast, where Doug and I will do a mock expert witness voir dire.